On the Common Link Theory by Fahad Alhomoudi. B. Generalizing particulars. Generalization is the second problem in Schacht's methodological approach. He constantly arrives at vague conclusions, some of which are derived from unsound premises. This was noticed by Motzki as well, who points to Schacht's misguided attempt to prove Goldziher's faulty thesis, that most hadith reports are historically unreliable. Yet Schacht's conclusions were even more general and radical than Goldziher's. In addition, Schacht's conclusions were based on legal traditions that were generally acknowledged by Muslims themselves to be fictitious. Schacht's general conclusion was widely understood to indicate that hadith reports were fabricated during the 2nd century after the Hijrah, or later, when early Muslim legal scholars developed their doctrines. In reference to Schacht's statements that the shorter versions of a tradition are usually older, the more elaborate ones younger, Motzki concludes that such a generalization is inaccurate. Besides the theoretical proof offered by Motzki for this rejection of Schacht's generalization, substantial historical evidence shows its invalidity. After a thorough study of the murder of Ibn Abi Luhukayk, for instance, Motzki states, "This leaves us with the thorny question as to which of the two versions is more original, the long one preserved by Waqidi or Zuhri's shorter one. As said above, following the ideas of J. Schacht, there is a tendency in Western hadith scholarship to regard the shorter traditions as being the older ones. In my view, there is no plausible reason why such a generalization should be accepted. Detailed narratives may be as old as shorter ones, and often the latter are obviously abbreviations of the former." C. Historical approach. Traditionists vis-à-vis secular historians. The third issue to be discussed here is Schacht's overall attitude regarding the Muslim and Western methods of hadith criticism, which he thinks to be irreconcilable, because they rest upon totally different presuppositions. The former upon religious faith and a strong notion of morality and moral rectitude, whereas the latter upon secular historical criticism. Alternately, some scholars such as Coulson believe that the truth lies somewhere between traditional Islamic legal theory and the historical approach of Schacht. But this apparently balanced solution perpetuates Schacht's false dichotomy between the approach of Western historiographers and that of Muslim traditionists. This dichotomy ignores historically tangible aspects of the traditionist epistemology, which cannot be neatly categorized as merely secular or religious, and more accurately reflects both quantitative and qualitative Dabt and Adala criteria. Their methodology does rely on piety or righteousness, but in a way similar to the requirements of moral integrity for witnesses, in order to provide testamentary evidence at Qadi's courts. In fact, traditionists maintained even more exacting standards for evaluated narrators than those applied to court witnesses. This was done to determine if a narrator was sufficiently dutiful Muslim in order to validate or invalidate their reliability. I have further explicated the objective criteria which constitutes the traditionist's definition of piety in this respect. In his assessment of the nature and sources of Islamic law, S.G. Vesey Fitzgerald contextualizes his approach within a broader conceptual phenomenon observable in the humanities. Quote, "The normal course of intellectual development in the humanities and the social sciences is that practice comes first and theory afterwards by a process of generalization from observed facts. Logical thought comes before logic, and society before the social sciences. Similarly, religion, any great religion, is older than its theology, and law is older than its jurisprudence." When Vesey Fitzgerald sought to discern the reflection of this phenomenon in the history of Islamic law, he took exception with conventional wisdom and assumed a position akin to Schacht. Quote, "Yet according to orthodox Islamic exposition, which was in the main apparently accepted even by such great scholars as Sachow and Snok Horonji, the theory came first and the practice was built upon it. However, from another dimension, practice did precede legal theory if we consider the Quran and the prophetic tradition as practical elements of Islamic law, and fiqh as the theoretical application derived from them. This was not how Schacht and Schachtians understood it. Their understanding was that much of Islamic law is pre-Islamic, making its practical elements pre-Islamic as well, long before being cast into the theoretical mould. Coulson adopts another approach to criticizing Schacht's basic methodology by providing an example of a valid tradition. He emphasizes that one example cannot affect the fundamental validity of Schacht's thesis, but it can call into question the degree to which Schacht's thesis holds true. On the other hand, Schacht's theory itself was not established upon a strong foundation because he used so few examples, and when he did, they were of rather irregular cases. Nevertheless, he presented them as the standard way of transmitting prophetic tradition. In so doing, Schacht created a historical anachronism, a historical fallacy which in turn reflects a logical fallacy, whereby a part is erroneously thought to represent the whole. Therefore, Schachtians cannot conclude from this that all traditions should be regarded as fictitious until their authenticity is objectively established. In fact, even by the standard of Western methodology, Schacht's subjectivity and rigidity prevent his approach from being modified or improved. Coulson experienced this when he wrote his book, A History of Islamic Law. Schacht criticized him strongly, rejecting his approach. Coulson responded to Schacht's review, explaining that their approaches to the subjects were basically different. However, Schacht appeared not to appreciate approaches other than his own. He persistently evaluated the subject matter of Coulson's book in the light of his own approach, a critical attitude that Coulson described as unwarranted, of unsavoury innuendo, and self-opinionated to a degree. In sum, Schacht translates the negative proposition that the evidence of legal hadith does not take us back beyond the 2nd century of Islam into the positive statement that legal development began only in late Umayyad times. Schacht's understanding of traditionist articulation of the CL is clearly in error, and its effects are not limited to his common link. Rather, it carries with it a number of important ramifications. For many of his other claims about early Islamic history, I will proceed to discuss some of these in the following chapter, Chapter 5. Stay tuned for many more parts.